Good afternoon to you. Today we will take CCA CCA rules, suspension. In the last class, we have seen a few Government of India's decisions on suspension. We will continue with a few more decisions taken by Government of India in due course of time. Number one, in the case of government servants involved in the dowry deaths, under section 304 of the Indian Penal Code, if a wife dies within 7 years of the marriage, then if there is any doubt about the harassment due to dowry, the government servant, if he is arrested, if a government servant is arrested in connection with the registration of a police case involving a charge of dowry death, he has to be placed under suspension, irrespective of period of detention. If he is not arrested, on the other hand, he will be suspended immediately on submission of the police report to the magistrate, provided the report prima facie reveals involvement of the official in the dowry death. This is one of the most important decisions given by Government of India in the case of dowry death. Similarly, in the case of revision of scale of pay, when the scale of pay of a post held by the government servant under suspension is revised, suppose the government servant is under suspension and with the scale of pay is revised with effect for the date prior to the date of suspension. Remember, the revision took place prior to the date of suspension. In that case, he can exercise option even if the date by which he is to exercise option falls within the period of suspension. He can exercise the option. Not only that, he is entitled to the benefit of increase in the pay, if any, for the period of suspension, and also increase in the subsistence allowance. That is the most crucial point. On the other hand, if the revision of scale of pay takes effect from a date falling during the period of suspension, we have to see 2 points. Number one, whether the government servant is holding a lien or not. In other words, whether he is a confirmed official or not. If he is confirmed, in that case, he can exercise option even under suspension. However, the benefit of option will accrue in respect to the period of suspension only after reinstatement, depending upon the fact whether the suspension has been treated as duty or not. That is the one decision. Suppose if the suspended official is not a confirmed employee or he does not hold any lien, he is not eligible to exercise option at all. However, if he is reinstated in the post and the period of suspension is treated as duty, then he is allowed to exercise the option after reinstatement. If necessary, he can be given extended time for exercising the option. So, this is a very important decision with reference to revision of scale of pay. So, if the revision is effective from a date prior to the date of suspension, he is entitled for all benefits, even though he is exercising the option during the period of suspension. On the other hand, if the revision takes place during the period of suspension, then you have to see whether he is a confirmed employee or not. If he is a confirmed employee, he can give exercise option, but the benefit of option will be available only after his reinstatement. If he is not a confirmed employee, he is not entitled to exercise any option. He can exercise option only after his reinstatement, and if necessary, he can be given a extended time for exercising the option. This is the 2 points which you should remember with reference to exercise of option. Secondly, CVC has given detailed instructions where it is appropriate to place a government servant under suspension and where it is desirable to place a government servant under suspension. Remember two segments. One, where it is appropriate to place a government servant under suspension. Secondly, where it is desirable to place a government servant under suspension. First, let us see on what circumstances it is appropriate to place a government servant under suspension. Number one, excuse me, where his continuance in office will prejudice the investigation, inquiry or trial. First thing, where his continuance in office will prejudice investigation, inquiry or trial, then it is appropriate to suspend him. Secondly, where his continuance is likely to subvert the discipline in the office. Subversion of discipline. Possibly his presence will subvert the discipline in the office. Second circumstance. Third is, where his continuance will be against wider public interest. For example, if there is a public scandal, let us say LTC scandal or medical reimbursement scandal, many people are involved, or corruption, many people are involved. So, government wants to show its firmness. In such circumstances, even sometimes, even innocent may be suspended for contributory negligence. So, where the government wants to show its firmness in dealing with scandals, the suspension can be resorted to. Then, where the preliminary inquiry has revealed that the departmental proceedings will ultimately end in the removal, dismissal or compulsory retirement of the government servant, or the criminal proceedings will ultimately end in the conviction of the official. If there is a prima facie case in these two, then the government servant can be suspended. Then secondly, obviously, where the activities of the government servant are prejudicial to the interests of security of state, obviously he will be suspended. It is appropriate. This is a statutory circumstance, so there is no question of any doubt on that. These are all the 5 circumstances under which the CBC has advised it is appropriate to place a government servant under suspension. Now, second point is where it is desirable. Where it is desirable to place a government servant under suspension. Number 1, where the offence involves moral turpitude. Where the offence involves moral turpitude. What do you mean by moral turpitude? Lack of integrity. Where the offence involves moral turpitude. Secondly, corruption, embezzlement, misappropriation, or possession of wealth disproportionate to known source of income, and misuse of official position for personal gain. Again, I repeat, corruption, embezzlement, misappropriation, possession of wealth disproportionate to known source of income, misuse of official position for personal gains. Then, thirdly, negligence or dereliction of duty resulting in considerable loss of funds. Number 4, desertion from duty. Number 5, refusal or deliberate failure to carry out the written orders of the superior officers. These three, the 3, 4 and 5, that is negligence or dereliction of duty resulting in considerable loss to the government, dereliction of duty, that is dereliction of duty is negligence of duty. Then next comes desertion from duty, all on a sudden disappears. Then refusal or deliberate failure to carry out the written orders of the superior officers. These 3, remember, it is some element of subjective decision is there. These 3, because it is undefined, negligence or dereliction of duty, where you can very well, concoct. That is, if there is a tussle between the superior officer, official supervisor and the official, there is a possibility of attributing motive. So, CVC has specifically said, in these three cases, when you resort to suspension, you should be very careful. Because, don't think suspension is just like that. Suspension not only additional burden to the exchequer for no work you are paying him half pay leave salary. Not only that, it demoralizes the official. See, it is as good as in a criminal case, you can let off 100 criminals, but you should not punish even a single innocent. So, that is why all the benefit of doubt is given to the accused, because the prosecution has another chance to prove the guilt. But once a person has been convicted, if an innocent has been convicted, it will demoralize not only the individual but the society. That is why in the criminal law you can let off 100 criminals. There is no use. There is no problem. But you should not punish even a single innocent. So in these three, there is an element of subjectiveness in these three in assessing the guilt. So that is why the CBC has said, when you exercise your discretion on these three, be careful. It has warned. You should be very careful in placing a government servant if he is involved in these three. That is number one. Now we are coming to Rule 11. Rule 11 gives you the penalties. What does it read? The following penalties may, for good and sufficient reasons, be imposed on a government servant. This is the actual wording. The following penalties may, for good and sufficient reasons, be imposed on a government servant. What is good and sufficient? Which is good and sufficient for me, it may not be good and sufficient for you. Remember, suppose let us say a person as I am a supervisory officer. I visit treasury in the what is called your treasury office. There is a shortage of 2,000 rupees. I may say shortage of amount. That is, what is it? He has not credit, non-credit of rupees 2,000. You may say this is misappropriation. So, according to me, it is a non-credit. Your view is, if the non-credit means where the money has gone, it implies that he has misappropriated. So, misappropriation of money is a greater gravity, more gravity than the non-credit. So, it is how a person looks at. That is precisely the reason why there is a appeal, there is a revision, there is a review, there is a judicial review, then there is a 32, Article 32 under the Supreme Court, and then Article 226, High Court. All these outlets have been given because there is an element of subjective decision. There is a possibility. See, every human being is imperfect. Any system evolved by a human being cannot be perfect. It is inherent. Imperfection is inherent in every system. That is why so many opportunities have been given, so many instructions have been given. So, for following penalties for good and sufficient reasons be imposed on a government servant. The penalties are graded one by one. Second is more than the first, third is more than the second, fourth is more than the third, fifth is more than the fourth, sixth is more than the fifth, and seventh is more than the sixth, eighth is more than the seventh, and the ninth is more than the eighth. So, every penalty is graded, and there is no strict rule that if a person is unauthorizedly absented from duty for 2 days, you can give him censure. If it is 5 days, you can give him withholding of increment. If 1 month, reduction in no such thing. There is no correlation between the misconduct and the imposition of penalty. It is totally left to the discretion of the disciplinary authority. There are cases where the government servant has been dismissed from service for unauthorized absence. There are instances where a person has been let off even after having committed the misappropriation for want of evidence. So, there is no strict correlation between the misconduct and the penalty. So, all penalty, that is why the word is for good and sufficient reason be imposed on a government servant. You have to read with reference to the conduct rules. That is all. So, if there is a good and sufficient reason, following penalties can be imposed on a government servant. This is what it says. Now, all the penalties are broadly divided into two categories. minor penalty and major penalty. What is minor and what is major, that you have to see. But see, according to me, it is my analogy. There is no rule on this. Whatever you are going to get, if it is deprived of, that is minor penalty. Again, I repeat, whatever you are going to get, if you are deprived of, that is minor penalty. What you have already got and you are deprived of, that is major penalty. This is broad. There may be one exception, but it is a broad. For example, I tell you censure. Let us say first censure. Censure means recordable warning. So censure, suppose you are going to get good CRs, outstanding CR this year. So that CR is not, you are not going to get it. So this is the effect, adverse effect is prospective. So that is a minor penalty. Second is withholding of promotion. Second is withholding of promotion. Whatever, suppose you may be an LDC, you might have been promoted to assistant, you might have been promoted to SOU, now occupying under secretary. So withholding of promotion means whatever promotion you are going to get, that will be deprived of. Whatever promotion you already got, it is not going to be touched. So withholding of promotion means the promotion which you are likely to get is being withheld. So it is a prospective effect, it is a minor penalty. Third, recovery from pay of the whole or part of any pecuniary cost to the government by the breach of order, negligence of the government servant. This is the third penalty. Remember, from your future pay, the amount is recovered. Because of your negligence, there is a loss to the government of rupees 4,000 rupees. That 4,000 is recovered from your pay, prospective pay. You are not in the it is not recovered from your pay you already got, from the prospective pay. So that is prospective effect, it is not retrospective effect, so it's a minor penalty. The fourth, that is 3A, which was added 2004, reduction at a lower stage, one stage for a period not exceeding 3 years without affecting the pension benefits and without cumulative effect. This, remember, it is technically a major penalty, but it is included as 3A under minor penalty in 2004. My analogy will not apply here because it is a reduction in stage. Whatever increment you got, one increment is reduced. This will not apply to my analogy. Another, withholding of increment. Suppose you have already got 3%, 3%, 10 increment you got. That increment is not touched. What the increment you are going to get next year, that 3% is withheld, withholding of increment. So this is a prospective effect, which is a minor penalty. So totally all the penalties are divided into minor and major. Whatever benefit you are going to get if you are deprived of, that is minor penalty. Whatever benefits you already got if you are deprived of, then it is called major penalty. That is the analogy which I have invented. So it applies your common sense except one, that is 3A, which was introduced in 2004. So we have now seen the minor penalties. Tomorrow at the next class we will see the major penalty. Thank you.